Thank you. Thank you. Have a nice day.
All right, next case we'll take up will be Florida Cardiovascular Association, PA versus, is it RAO, Mr. Peters?
Yes.
All right, okay. All right, you may proceed.
Thank you, Your Honor. My name is Mark Peters. I'm an attorney from Viera, Florida. I represent Florida Cardiovascular, who is the appellant here, defendant below, and also had a counterclaim. I'd like to address two issues.
Would you like to reserve time for about?
I would. 5 minutes, please, Judge. The issue that we raised on appeal really are twofold. This was a contract case involving physicians. There was a recruitment agreement and an employment agreement, and there was a dispute concerning how much money the plaintiffs in this case were underpaid for a period of time which they worked for my client, which was from August 1st of 2006 until December 31st, of 2007. That dispute came before the court for a non-jury trial, and immediately prior to the trial, we had a rather long evidentiary hearing concerning whether or not the counterclaim should be struck as a result of violation of discovery orders that were entered by the court concerning the production of documents. These documents are referred to as EOBs, explanations of benefits, and were part of the case to prove that there were damages caused by the plaintiffs due to their failure to bill while they were working for the appellant in the case. That evidentiary hearing resulted in a ruling by the court that struck the counterclaim in its whole and limited, as you will see from the transcript, my abilities to present evidence concerning the defendant's breach of contract and the damages that were suffered by the by the defendant appellant in the case, which included the cost of reconstructing records concerning patient care and money that was lost as a result of inability to bill or recover for services because the bills were submitted too late to various health insurance companies and or to Medicare.
Would you agree that your client failed to comply with discovery requests on the explanation of benefits?
I do.
Okay. Would you agree that failure to comply was over an extended period of time despite numerous requests?
It was over an extended period of time, Judge. As the court's aware, and the initial counsel in this case withdrew on the eve of trial as a result of a family illness. And the record will reflect that the disclosures that were made prior to his withdrawal did not even include any expert having been hired in this case, despite the fact that this case was set for trial on a December 3rd trial docket. He had withdrawn either late October or early November of that same year. So that there had been a gap. As the judge indicated in his ruling, the ball had been dropped. I think the significance of the court's ruling, both his oral findings that appear in the transcript and what his ruling was itself, consistent with, in fact, an opinion that you wrote, was that there was no finding that there had been a willful or deliberate effort by my client in order to avoid the production of the documents that had been ordered.
Was there evidence that the other side incurred up to $12,000 of cost from their expert that they may well have been able to avoid if your client had timely produced?
Yes, there was.
Would that have been a possible sanction to have your client pay for their expert's needless work?
Your Honor, it was an alternative to the more severe sanction of obviously striking all of the pleadings. What happened in this case, and Judge Mall struggled with this, was clearly he was trying to come up with a pragmatic solution, but it didn't meet the legal requirements of what he was trying to do based on his own ruling. The pragmatic solution obviously was predicated on there being a huge disconnect between what the original claim of damages was, some $350,000. And the end result of the review of all these EOBs, where it was somewhere in the $18,000 to $12,000 range, together with some additional damages for the cost and labor involved in reconstructing all of those accounts. We were precluded from presenting even any evidence concerning the cost of reconstructing the accounts and doing this kind of forensic examination of the medical records and medical care provided by the plaintiffs in the case. So no part of the damage claim came in, including any part concerning the explanation of benefits. Well,
Did the trial judge have awarded attorney's fees against your client?
that is an alternative sanction, as you know from your own opinion.
Between that and the $12,000 for the expert, I mean, he may well have given a break to your client financially.
That was the pragmatic result of what he was doing, and that's what my comment was, that I think that's what Judge Mall was trying to do. But again, he didn't make the findings that were necessary in order to have the more severe sanction, which was the striking of the pleadings. The main issue, I think, in this case is whether the court erred in finding that there was substantial competent evidence that these folks had modified their written agreement by a subsequent oral agreement. As the court knows from the record, sometime in late October, early November of 2007, there was a meeting held between the 4 physicians that were working in this group, and there was a decision made by Dr. Modi, who was the primary owner of this group, before Dr. Matthews was joined as a shareholder, that he was not going to ask the plaintiffs to become a shareholder in the corporation. That meeting precipitated a series of additional meetings between Mr. Mkhitaryan and Mr. McAlpin, who are involved with the hospital, where they were trying to massage this group back into a successful practice.
Didn't Dr. Modi during his deposition testify that there was a mutual agreement that the RAOs were going to leave at the end of December 31st? Didn't he make that?
Dr. Modi said, he did say in his deposition, to be honest, Dr. Modi's testimony was disconnected in a lot of areas, I think would be a fair description of it. He said that he retracted it. He retracted it again at trial. There's a retraction of that actually in his deposition transcript as well. He said that there was an understanding that they would leave, that there was no date that had been agreed to.
But weren't the locks changed on the door at the end of the year?
There were. The locks were changed. There was testimony, and again, a disconnect between 4 different people's testimony, that Dr. SURYA Rao said that he went to the office with his brother on December 31st, that he gave to Dr. Matthews this envelope that had their resignation letter in it that I'm going to address with you later. And then there was some lack of clarity as whether the locks were changed after that, because Dr. Ravi Rao testified he went later to hand in billings, and at that point the locks had been changed. So Dr. Ravi Rao's testimony was that the locks in the office had been changed sometime between December 31st and January 1st. So yeah, there is some disagreement concerning that testimony, and obviously it was in conflict. The real issue is there substantial competent evidence in the record of this case that there was a meeting of the minds at some point between this meeting in November and this announced letter of December 31st, 2007, where there was an agreement to waive the notice provisions of this written contract, so that all of the parties had an express understanding of and recognition of this is what we're now agreeing to do. And I would suggest from the testimony that's not in the record. Mr. Mkhitaryan testified that there was a meeting on December 21st of 2007. So as late as December 21st of 2007, these parties were still trying to reconcile their differences to continue practicing. That flies in the face of there having a specific oral agreement at some point before that we're agreeing to separate. December 31st is the last day, we're each go our own way. Also flying in the face of that is Dr. Ravi Rao's testimony, where he said at trial, I may not have finalized my plans until December 31st. So clearly there was no agreement as to all of the essential terms of this is how we're separating, this is when we're going to do it. There was no evidence in the record that there was any consideration for a new oral agreement to modify the written agreement between the parties that clearly called for a 60-day notice period.
Wouldn't there be mutual consideration that they both have the right to not give 60 days?
That could be it if they reached that agreement. But there's nothing in the record to say, we sat down. If you look at both Dr. Rao's testimony at trial and their deposition transcripts that I used to cross-examine them, Dr. Ravi Rao said, well, we had this understanding and I inferred it. I asked him specifically, did you ever have a conversation with anyone at Florida Cardiovascular that you told them you were leaving on December 31st before you gave them this letter on December 31st? His answer was no. I don't remember any specific conversation about a specific date, which is consistent with what Mr. McAlpin and Mr. McItarian say, which is that as late as December 21st of that year, they were still working at either smoothing out the divorce or some sort of reconciliation. You know, if you look at the letter that was turned in by the two plaintiffs in the case, it says, November of this year, you decided not to offer Surya or me partnership into the group and that our employment would be terminated on December 31st, 2007. Surya and I accept your decision to terminate the contract today. Well, if they'd already had an oral agreement, if they had already finalized and had specific terms of an agreement, there would be no reason for this letter. One, they wouldn't have had to give notice, and two, they wouldn't have had to give an acceptance on the very day they were leaving. Obviously, the importance of the notice is under the terms, the rest of the terms of the contract. There was a forfeiture or a liquidated damage clause that said, if we owe you any money and you fail to comply with the 60-day notice, you waive any funds that are owed to you as a result of your breach of the 60-day notice provision. The non-enforcement of that specific language, but the enforcement of every other part of this contract by the judge, is essentially a rewrite of the contract by the court. The court found that without any written documents or any specific agreement or any terms of a specific agreement, that part of the contract was waived by my client and therefore rendered unenforceable the provision that provided that the RAOs would waive any sums that were owed to them as a result of their breach of this contract. We think that the court made error because there's not specific evidence in the record to support that. I still have some time left. Does the court have any questions for me?
All right, I'll leave the rest of the time for your rebuttal.
Thank you, Judge.
Morning, Your Honors. David Steinfeld on behalf of the appellees, the RAOs. I was the plaintiff's trial attorney below as well, opposing Mr. Peters. Before I begin, since there are three distinct issues that the appellant has laid out, one is the issue with the contract, the second is the issue with civil theft claim that the Florida Cardiovascular brought, and the third is Judge Maul's decision to strike the counterclaim. Are there any specific areas that the court wishes to focus on? I noticed that the appellant did not address the civil theft claim issue. These have been well briefed by both parties. To save some time and energy here in judicial labor, is there any area that the court would rather focus in on?
Why don't you go ahead and start with the main issue,
Yes, sir.
the contract issue.
Okay. Case law is very clear. The WSOS versus Hayden case that this court has cited and decided about 7 months before the parties entered into this arrangement makes it very clear that if you have a contract that says it cannot be orally modified, that can still occur as long as the parties have an arrangement, and to not enforce it would be to work a fraud or an imposition or an injustice on the party. Here, the trial court, Judge Maul, was tasked to determine whether there was substantial and competent evidence. That was the standard that he was guided by from this court. Substantial and competent evidence to determine whether these two parties agreed that there was going to be a split at the end of the year, some 3 months before the contract was to expire. And there was substantial and competent evidence in the record to support this. Judge Maul found that the way that these parties arranged for the split was in compliance with Article 10 of the recruitment agreement from the hospital. And the recruitment agreement had to be read, as Judge Mall found, together with the employment agreement. These were all part and parcel of each other. And just to back up to give you the clear overview, I know that your honors have read the record. My clients were invasive cardiovascular surgeons. One does the stents, one does the pacemakers. They were recruited to this area from Chicago. They were brought down by the hospital with a recruitment agreement. And because the hospital cannot directly perform that action, it's ordinary practice for them to place them and support them in a local practice. That's how they connected with Florida Cardiovascular and worked at Florida Cardiovascular. Over the course of their time there, it's clear, and the judge found, that they were not paid the salary that they were promised. That's not in dispute. At the end of 2007, Mr. Mkhitaryan, who was the CEO of the hospital, testified by deposition at trial, and we had his actual calendar records showing that he met with both of these parties separately and together to try to bring them together and have some kind of an orderly transition or resolution to their practice difficulties and differences. Then we had the testimony at trial from the CFO of the hospital, who said he was directed by Mr. Mkhitaryan at the end of November or the beginning of December to start writing up an employment contract for these two physicians, my clients, starting January 1st, 2008. So at that point, the hospital, who has somewhat of an interest in this but is not one of the parties, is sensing that the parties are going to split apart and they want a fallback position. They want to employ my clients at the hospital. Then we have the testimony of Florida Cardiovascular's very own office manager, Patty Reisinger, who said that on December 8th, she got a phone call from someone at the hospital telling her that on January 1st, my clients, the RAOs, were going to be employed at the hospital and asking for her assistance as the office manager of Florida Cardiovascular to help in the transition and moving patient files and things like that. And she said yes, she would help with that. Then we have Dr. Matthews, who at the time was an employee and was becoming one of the partners of Florida Cardiovascular. He testified that he was told by Dr. Modi that the RAOs were no longer going to be at Florida Cardiovascular come January 1st, 2008, and Dr. Matthews doesn't put the RAOs on Florida Cardiovascular's call schedule from January 1st, 2008. So if there's no meeting of the minds, and these parties up until the end of December of 2007 have no idea whether the RAOs are going to be there or not, why isn't Florida Cardiovascular making a call schedule and including them on it? Why, as Judge Berger pointed out, why is Florida Cardiovascular changing its locks and locking my clients out so that they can't go in and get their personal products, personal property out of the offices? Because Florida Cardiovascular knew very well from its conversations with the hospital, from everyone involved, that my clients were going to start work at the hospital as employees on January 1st, 2008. Then we come to Dr. Modi himself, who was at that time the sole owner of Florida Cardiovascular. He testified, as Judge Berger pointed out, in his pre-trial deposition. He was asked by my co-counsel, Mr. Levenstein, was this agreed? Was this a mutual termination that was going to happen on December 31st? He said, which doesn't help anyone because it's not verbally recorded. So Mr. Levenstein says, yes, which appears in the record, yes, question mark. Dr. Modi says, yes. At trial, he recants his testimony and he tries to double back from that when I challenged him on it, and he says, no, this wasn't mutual. I didn't really mean yes. I was just answering yes. I was parroting yes. Mr. Levenstein asked me and I mumbled something, and then he says yes, and I just said yes. I randomly just parrot answers back to people and say yes. Clearly, when you read the record and you see the transcript, and it goes on for about 10 pages in the trial transcript, Dr. Modi testified pre-trial that this was agreed, this was mutual. Everyone, including the hospital, knew that the RAOs were going to leave as of January 1st, 2008. And then, because that wouldn't help their position at trial, Florida Cardiovascular then changes it and says, no, we had no idea, they should be penalized. And the money that we got, Florida Cardiovascular got from the hospital under the recruitment agreement to pay these physicians their salary, that Florida Cardiovascular kept because the judge found very clearly that they didn't pay the full salary. So that means it wound up in someone's pockets, and it's not in the hospital, it's not in the RAOs, so it's in Florida Cardiovascular's hands. Florida Cardiovascular should be allowed to keep that excess and be enriched by that amount and shouldn't have to pay it to anybody simply because they want to say they didn't know, even though the evidence overwhelmingly is to the contrary. I can speak to the other issues. I'm happy to do that. I just don't want to extend any time. On the civil theft charge, I think it's very clear that that is a higher burden to hit. That is clear and convincing evidence. The evidence was very, very clear at trial, and Judge Mall found that Florida Cardiovascular did not meet its burden of proof or even approach that. There was a separate medical directorship contract that was part and parcel of Dr. Ravi Rao's employment or recruitment agreement, or both, that was incorporated into it. And
the
yes,
check
ma'am.
that was given to Dr. Rao
Yes.
for, which I guess normally would be deposited into the account of cardiovascular, and then they would pay him. This particular check, am I correct in that it was made out to both cardiovascular and to the doctor?
No, ma'am. The particular check was made out at that time directly to Dr. Ravi Rao, and it was made out by Tina Phillips, who was an employee of the hospital. She was in the cardio.
So he cashed a
application.
check that was made out to him?
Yes, ma'am.
All right.
And he was always entitled to all that money as the medical director. There was no money that was going to be held back by Florida Cardiovascular at all for any period of time, and that was Patty Reisinger, the office manager of Florida Cardiovascular. That was her testimony, that whenever they would receive the money, it was immediately paid to Dr. Ravi Rao. They had no right to even hold it and invest it or earn any interest or anything off of it. It was all his money. So you can't steal from yourself, very clearly, and he had nothing to do with the crafting of this check. Tina Phillips testified she was the one who decided to write it to Dr. Rao because she thought that's what was supposed to have happened. So clearly he can't have any of the necessary mens rea or mental process to commit some sort of a criminal offense. On the, Judge Evander,
What's
you
your
look like you-
response to opposing counsel's argument that given the trial judge found that there was not a willful and deliberate attempt to not produce the explanation of benefits, that it was inconsistent to then impose the sanctions that the trial judge did?
Okay. The case that I've cited in my brief from this court makes it very clear that there is no magic language. You don't have to say willful and deliberate. It has to rise to that level, but you don't actually have to call one of the parties out and say you willfully and deliberately withheld this evidence. To understand what this was.
But here there wasn't an omission. The judge made a finding that he could not find willful and deliberate.
Yes, yes, sir. But what the judge was required to do, and this was well briefed by both parties in the pretrial motions, the judge was required to examine all the facts of the circumstances. The judge was required to weigh and consider all of the options that he had available to him. And the judge was required to enter a written order and a ruling defining why he chose the path that he chose and why he excluded certain others. That meets his requirement to demonstrate that he is using appropriate discretion in this situation, and it insulates him, if you will, from being called on abuse of discretion. He did all that. He satisfied that. To not give effect to Judge Mall's decision at the trial is tremendously impactful to all trial judges, because it says to them, regardless of the decisions that you make, you with boots on the ground, seeing the witnesses, deciding the case, making the decision how to run your court most efficiently, regardless of the decision that you make, we're going to second guess you. And that is not really fair to Judge Mall. He lamented for quite a while over what would be the appropriate response. And Judge Berger, you pointed out, I believe, whether it was, I'm sorry, Judge Evander, you mentioned earlier that was a possibility that costs could have been paid for our expert, that attorney's fees could have been paid. Judge Mall examined all that. And what he found was this case had been delayed significantly for quite a while. We were right on the eve of trial, that to delay it further would be inappropriate and work an injustice on both sides. There would have been more cost involved, he found, and he really went through these at great length, both at the hearing and in his order, it would have been more expensive for us to have to come back and put on proof of the costs and the fees and everything, and it wouldn't have solved anything. Really what happened, when you look at the forest for the trees, throughout this approximately 2 years of litigation, Florida Cardiovascular maintained this counterclaim that my clients had not turned in some kind of records that they were supposed to, and therefore Florida Cardiovascular didn't have the documentation necessary to submit to the insurance company so they could get reimbursement. They claimed $356,565 in damages and testified in deposition, Patty Reisinger specifically, and in response to not one but 2 interrogatories and 2 requests to produce, that they did not have any documents to support that number because they did not submit any of this stuff to the insurance companies because it was too late when they discovered it and it was past the time to do so. Then, about a week before trial, these documents that were sent to insurers and paid by the insurers magically show up in the hands of this expert witness who's testifying about these EOBs. It was critically important for my clients to be able to demonstrate that Florida Cardiovascular got nearly all of the money it claimed from the insurance companies. It was an outright fabrication for Florida Cardiovascular to say they didn't get paid at all. Those documents showed that they did, and they had them in their possession. Judge Mall grilled Patty Reisinger, the office manager, while she was on the stand at this hearing and asked her where these things were, when she had them, when she discovered. She said the whole time they were sitting in her file cabinet in her office, and she knew what they were. They never turned them over because if they turned them over, it would have dispelled their entire damages case, and we would have been able to wipe that thing out and show that they had no damages. This $12,000 to $18,000 number was a guesstimate that was put on it as to sometimes not all the money is paid. If you claim $100, you get $98 from the insurance company, so there may be a little margin for error there or something like that. But what Judge Mall did when he assessed what would be a fair response is he looked at all the options, and because I left in the first 2 affirmative defenses, which were the breach claims, Judge Mall said that would be fair because Florida Cardiovascular could still put on evidence of the alleged breach by my clients of these employment agreements. Therefore, we would still have the same issues in the case. It would just remove the damages and it would be fair. What happened through the trial process, which puts us in the position we are today, is that Judge Mall found that there was no breach. There was an allegation, and Judge Mall in the record was very clear with appellant's counsel as to specifically what was their breach claim, what were the components, and they said the RAOs violated administrative rules. They did not turn in these records to the hospital, to Florida Cardiovascular, and Florida Cardiovascular could not bill the insurance companies. Florida Cardiovascular had the opportunity through its first and second affirmative defenses at trial to put on any evidence it wished to prove what these administrative procedures were. They didn't because they had none. In fact, Judge Mall found in his final judgment that they had the opportunity to make administrative rules, and they didn't. They had no administrative rules that could have been violated. Second, the evidence at trial also showed that Patty Reisinger was going to that cath lab and picking up on a weekly basis all of the records showing the work that my clients were doing. So even if they hadn't turned something in to Florida Cardiovascular all along knew exactly what my clients were doing because they were picking these records up from the lab at the hospital at which they were working. Judge Mall found that there was no breach of the agreement on the part of my clients. So therefore, because you have to have breach and damages, if you don't have the breach, you never reach damages. That's why I said in my brief that if the court for some reason would find that this was too severe and it would override Judge Mall's discretion, what would happen is it would go back to the trial level and those facts remain static. The trial court is just going to simply find that there was no breach of the contract by my clients, so therefore we never reach damages. So Florida Cardiovascular has not been prejudiced in any way. So it becomes kind of an academic issue. But I do feel, based on what is in the record, that Judge Mall did his best. He really tried to give a balance back to the situation. He went through, both at the hearing and in his written order as he's required by law, all of the options, from weighing the awarding costs, attorney's fees, doing other actions, not allowing certain evidence in. And he felt in his discretion, his sound discretion, the best way, as he said, to rebalance the situation on the very eve of trial was to strike the counterclaim, which literally just took out the damages portion. They still had the opportunity to put on evidence of breach, and they couldn't prove breach, and he found that they didn't prove breach.
Any questions? Thank you.
Thank you, Your Honors.
With all due respect, the issue that Florida Cardiovascular received money as a result of the recruitment agreement that was guaranteed and kept this money and didn't pay it to the RAOs is simply inaccurate. The testimony and evidence is that it was only during the first year, from July 31st, 2006, through August 1st of 2007, that the hospital was involved in guaranteeing this contract. The undisputed evidence at trial is that all of that money, the $100,000 signing bonus and the $400,000 in salary during that year, was paid. There was no guarantee or any monies received from the hospital or their affiliate corporation starting August 1st of 2007 through December 31st of 2007. That was the period of time that the courts determined that the appellees in this case were underpaid. So there weren't funds received as a result of the guarantee agreement that were not paid to the two plaintiffs in this case. There's a lot of evidence that there was no agreement to end on the 31st. Counsel mentions that there wasn't a call schedule set up. Well, call schedules, according to the testimony and evidence in this case, are established by the hospital. There were patients scheduled to be seen by the RAOs in Florida Cardiovascular's office after December 31st of 2007. That flies in the face of anyone in this group having an understanding that they were going to be gone. There was ample testimony that no patients had been informed that the group was splitting up. There had been no public notice, as required by statute, that their records were going to be in a different place than where their doctors were. So this record is replete with testimony and evidence that there was not a specific understanding. This court in Holloway versus Gutman, which is a case from 1998, said that you can't infer a new oral agreement, that there has to be specific testimony and evidence concerning all of the essential terms, or you don't have an oral agreement that would modify the terms of a written agreement. We have not argued here or at the trial court that a written agreement cannot be modified by an oral agreement. We have argued there and here that in order to modify it, has to meet all of the same requirements that a written agreement does. And I don't know how you get that from this record, that there was a specific agreement reached. No one can identify a time or a date when there was even conversations that happened.
What was Dr. Modi's testimony on the locking of the offices?
He's gone by then. He doesn't know. Remember, he's traveling for a honeymoon where he's gone for 5 weeks.
Who made the decision to lock the...
It had to either be the office manager or Dr. Matthews because no one else was there. I'm not sure there's any testimony or evidence in the record who made that decision. Someone did. Dr. Modi was gone.
But how is there not a meeting of the minds as to when the employment contract is going to be terminated by locking the doors? I mean, it seems to me inconceivable that they would change the locks on the doors on the 31st if there was not an agreement and a meeting of the minds that the employment contract between Cardiovascular and the RAOs was going to end, just as the doctor testified to in the deposition on the 31st of December.
I think the evidence is convincing that could have occurred. The changing of the locks occurred after the delivery of this letter. If you look at page 766 of the trial transcript, Dr. Ravi Rao's own testimony was that the locks were changed sometime between the 31st and the 1st. They clearly got into the building according to SURYA.
Wasn't there contrary testimony from the other doctor?
There was.
And the trial judge could
He could have gone either way, but I'm saying,
But if he chose the other brother's testimony, would that support a conclusion that the appellant had changed the locks prior to the letter?
the testimony from the RAOs was from Ravi Rao that when he went to deliver billing information, the locks had been changed. Both of them Ravi Rao didn't recall when the letter was handed to someone at the office or to whom it was handed. Surya Rao testified they both went to the office on December 31st. He didn't say anything about not being able to get in on that occasion. He didn't say anything about having to knock on the door or have someone come there. He said, we went and handed to Dr. Bijou Matthews these 2 or 3 letters that I'd read to the court earlier indicating we're resigning that day. That's what his testimony was.
Well, we're accepting your termination.
Yeah, we're accepting something that happened back in November.
You're
Well, if they're
terminating
accepting
us.
it that day, how did they have an agreement already? Why would you have to do that?
If they're sending a letter in to them on the 31st that says, we understand you want to terminate the employment contract, we accept that termination effective whenever. I mean, that's not, I resign effective today. That is, the way I read the letter is, you wanted to terminate the contract the 31st, we agree. Here's your letter that sort of finalizes everything.
Why are you doing it that day if you already have a meeting of the minds that we're gone? Why haven't you moved your things out of the office before the 31st if you already have that meeting of the minds? Why aren't patient files being transferred to a new location for the patients of the RAOs if there's already a meeting of the minds? Why do you still have?
They're not taking patients with them, right? They're going to the hospital. Wasn't that everyone's understanding? That they would be the hospital, even though there might be a dispute on the date, but that was kind of the agreement, was they were switching from Florida Cardiovascular to the hospital.
They were going to become direct employees of the hospital upon leaving Florida Cardiovascular's employment. That is what the understanding was. The when and how is what there was no agreement about.
All right, and as far as the when, would you agree that at least the following individuals had an understanding at some time that it was going to be December 31st, January 1st, and that's Dr. Matthews, your client's employee, your client's office manager, the hospital CEO, the hospital CFO, and the appellees, and your client, at least arguably a deposition.
There was testimony, there was both for and against those propositions. I mean, Dr. Mkhitaryan said that he didn't have any sense there was a mutual understanding, and he was referring to the December 21st meeting, that there had been a mutual understanding at that meeting about what was going to happen. That's on page 636 of the transcript. He went on to say that there were still things that were left to be determined, that there was no oral agreement concerning any waiver, and they never discussed any waiver of written notice. That's on pages 662 and 666 of the transcript of the trial. So an independent party who's trying to readjust this so as not to disrupt services to patients is saying as late as the 21st that he didn't observe any sort of mutual understanding in this last meeting between the parties that he was present at. Does the court have any other questions for me?
Well, did Dr. Ravi Rao testify, did he not, that it was after he discovered the locks were changed that he turned in the formal resignation letter?
No. He said he didn't know when he turned it in or to whom at the office. It was Surya Rao testified that he handed the letters to Dr. Matthews, and that's on page 899 of the trial transcript. Dr. Ravi Rao testified he didn't know who he gave the letters to on December 31st.
But didn't he testify that it was after he noticed that the locks were changed?
I don't remember that sequence, because he testified on page 766 about the locks being changed somewhere between the 31st and the 1st.
All right, your time is up. Thank you both.
Thank you, Judge.
We'll take a short break and join the attorneys who wish to join us in the attorney's lounge for coffee.